Okay, hi everybody. This is Christie from the law office of Christie Asselin. Okay, so I've had quite a few requests recently for some very simple and quick estate planning. We're going to talk today about the California statutory will. This is a form that you can find online and download at home. I'm going to link to it via a blog post in the comments section and in the description. As you may know, I describe a will as the way that you gather all of your assets and say where you want your assets to go. In addition, a will is also the place where you can nominate guardians for your children, your minor children. Of course, this can come in handy right now because there's a lot of anxiety out there about what happens if I am incapable of taking care of my children because I'm sick with COVID, or if you pass away because of it. First things first, you need to know that your child's natural parent is going to be the person that will take over if you're unable to. So in the event that you and your spouse, or the biological child, the biological or adopted legal parent of the child, if both of you are unable to take care of the child, or if you've passed away, then the court will come into play and will designate a guardian for the child. Hopefully you cannot hear my 2-year-old screaming in the background. I just lost my train of thought. Oh yes, so this is a way that you can nominate your preferred caretakers, which is a really good thing because it lets you have a say in terms of who should take care of your kid if you cannot. The court, of course, will be involved in determining whether that particular guardian is in the best interest of your child. Okay, so the will, first things first, we're in kind of an interesting time right now with the physical distancing requirements that the state of California and various municipalities are under. And that's because, in general, most of the estate planning documents, including your advanced healthcare directive, your powers of attorney for health and financial issues, as well as your trust, they all need to be notarized. I think there's a very strong argument for notaries being, and this actually may even be in the executive order, notaries being an essential service provider. Attorneys are listed as an essential service provider, so I think support staff, such as a notary, I say support staff, but I mean support for executing these documents, would fall under the category of an essential service provider. There is some movement to ask the federal government to pass legislation which will allow these documents to be digitally notarized, which means that direct contact will not be required. If you've ever had a document notarized before, you know that you have to be in the same room and you have to show proof of your identification, and it involves taking a thumbprint as well. So there is a way to get around that, and you can do some social or physical distancing when required, but I think for everyone's safety, an emergency order or legislation would be fantastic right now. Getting back to the will, a will does not need to be notarized. In fact, it should not be notarized. There are some very strict requirements for executing a will, including that you must have 2 witnesses observe you signing the document at the same time, and then they have to witness the will as well. That's a tongue twister. Witness the will as well. Okay, so let's go through this. You and your partner will both need to have your own wills. You can indicate specific gifts. Here it starts off with a specific gift of personal residence. Just know that the threshold for opening a probate matter in the event of someone passing is when assets over $150,000 and have basically no place to go. If there's not a joint tenancy, if there is no beneficiary at issue, in the event that an asset is basically homeless, the court will get involved to grant an order. Probate, as you probably know if you've ever talked to me about estate planning, is expensive and time-consuming and avoidable. If you have assets over $150,000, a will is not going to avoid probate. You're going to have a trust to do that. However, these are weird times, and I think that having a will might bring some peace of mind in terms of designating guardians or nominating guardians for your children. If you have assets over $150,000, I just have to give the disclaimer that a will is not going to avoid probate. You need to have a full trust. When I draft estate plans, I draft a will, a trust, powers of attorney, and advanced healthcare directives. So that's necessary, but just for now, I think as a stopgap measure, I'm going to just talk about the statutory will. So here you can also designate where you want your household and personal effects to go to, and specific gifts of cash, and then the balance of where you want your assets to go. And I'm going to note that they, in this form, they indicate different layers of people that that you nominate as beneficiaries. And that's because you want to make sure your asset has a place to go. If you designate your spouse as the only beneficiary, then what happens if your spouse isn't able to take? What happens if you and your spouse pass away in a car accident? So you need to nominate layers of beneficiaries. Okay, here comes the important part, I think, for most of you, which is your nominated guardians for your children. Again, you see you want to nominate several layers of people to the extent you can. So there's two different types of guardian. There's guardian of the child's person, and there's guardian of the child's estate. Guardian of the child's estate is what I consider the CFO. It's the person that handles the child's financial and property issues. And then you have someone designated to handle just like the day-to-day care of the child, making sure the child's in school, receiving an education, eating properly, just the general day-to-day care of the health and support of that child. So for some people, those are going to be two different people. But for most of us, I believe you would nominate the same people to be your guardian of the child's person and guardian of the child's estate. Just to note that this actually refers to the guardian of what I refer to as guardian of the child estate as special provision for property of persons under age 25. So that's where you can do that. Okay, and here's what you nominate your executor. Your executor is the personal agent and responsible for ensuring your will is followed. So again, you want to nominate people, 3 different people, or at least 2 different people. A bond is typically not required for a will, and this is the way that you can say it's not going to be required. You just say no bond shall be required. And here again is where you have to designate 2 witnesses, 2 adult witnesses, to witness you signing the will. And again, it's signed under penalty perjury by these witnesses, that they understand that it's your will, that you have signed it in their presence, and that you are of sound mind and memory, and that the will was not signed under duress, menace, fraud, or undue influence, and that both of you are over the age of 18. Maybe you can hear my son in the background. He's trying to break in. Okay, so where was I? Yes, okay, so you have to have at least 2 different witnesses, and notarization is not going to do it unless and until we have a federal law or state law or order passed. The rule of the land right now is that the wills have to be witnesses. And okay, thank you so much. You can always ask me questions. You can visit my website at lawyercma.com. And again, lawyercma.com. And I hope everyone is staying healthy and safe.